No, sir.
All
All
right.
right. And Vinny, I didn't look at the end. Is there a request for a PSI on it, or do you have one?
I mean, I haven't filed anything with you folks.
Yeah.
So
Let me see. At the bottom of the plea petitions, often they have them. I don't think yours did. I'm going to send you a blank. I'll do that right now. I'm going to send you a blank PSI request. It's just something that we send over to probation so that they can.
Judge,
Um,
I just pulled up the one from writings. You don't need to. Yeah,
okay, awesome. And if you can, do you have the email to send it to?
yes, it's still in the same email.
Yep. Okay, awesome. All right, we'll get going. Mr. Freeman, here's what we're going to do. I'm going to call your case here in just a second. Can you hear me all right?
Yes, sir.
Okay. So once we get started, I think he's taking care of some kiddos. All right. Once we get started, I'm going to ask you a bunch of questions. All right. If I
Yes.
ask you something that you don't understand, I need you to tell me that so you and I can talk about it till I make sure that we're both on the same page. Okay.
Yes, sir.
And if at any time you want to talk to Mr. Rivera in private before you answer one of my questions, you just tell me that. I have the ability to send you guys to a private room to talk. Okay.
Okay.
All right. And the first thing, I'm going to call the case and then I'm going to have you sworn in, and then we'll get right to it. So with that, I will call two cases, those being 2018 TR 1996 and 2019 CR 1170, both of them captioned State of Kansas versus Reobert Freeman. Would the parties announce their appearances, please?
Please, the court, Your Honor, the state of Kansas appears through Assistant District Attorney Mark Brinkworth.
Your Honor, Mr. Freeman appears in person on video with counsel Vincent Rivera.
All right. We are here set down for a plea hearing. Kind of gave Mr. Freeman some instructions before we got started. So the first thing I need to do is have you sworn in, Mr. Freeman. If you would raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can go ahead and put your hand down. All right, Mr. Freeman, how far did you go in school?
Ninth grade?
All right, you read and write okay?
No.
All right. So Mr. Rivera tells me that he went over this plea petition that I'm going to show you in a second. Was he able to help you read through it, answer any questions you had about it?
Yes, sir.
Okay. As you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might keep you from understanding what we're doing today?
No, sir.
Feel like your mind's clear?
Yes, sir.
All right. Now, do you know what you're charged with in the original information?
Yes.
And you understand you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on those charges. Do you understand that?
Yes, sir.
Right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Rivera would help you throughout that case, throughout that trial. He would cross-examine and confront all the state's witnesses. He could call any witnesses that you wanted called. You could testify at that trial, or you could decline to testify. And if you decided not to testify, the state couldn't use that against you. In other words, they couldn't argue to the jury, well, Mr. Freeman must be guilty because he didn't tell you his side. Do you understand all that?
Yes, sir.
All right. If you had that trial and at the end of it you were convicted, you would have the right to appeal that conviction to the Kansas appellate courts. If you didn't have money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Now, if I accept this plea today, you're going to be waiving all of those rights that I just talked about. There's not going to be a trial of any kind in this case. Do you understand that?
Yes, sir.
All right. I'm going to go ahead and pull up this plea petition right now. There. Keeps coming up with that. Let me see if that's right. No, that is not. All right. Can you see that document, Mr. Freeman?
No, sir.
No? Is it not?
It's on my screen, but it's too little.
Okay. All right. And I'm not going to ask you to read it. I'm just going to ask you, is that the document that you and Mr. Rivera went over? Can you tell?
You've got the order accepting up.
All right. It's, let me stop that share. It's not cooperating with me today. Hold on. Now let's see if I can get it to show up. God, keeps coming. Oh, there it is. All right. Now we're going to start this again and see. Can you see that, Mr. Freeman?
Yeah, I can see it. Yeah, it let me make it bigger when I touch it.
I didn't understand that. What was that again?
It let me make it bigger when I touch it.
Okay. So does that look like the document that you and Mr. Rivera went over?
Yes, sir.
All right. And again, I'd ask you, did you understand everything in it in talking with Mr. Rivera?
Yes, I did.
All right. I'm going to go down to where it has what's called the plea agreement, and I'm going to read that to you. It's rather lengthy in this case, but we'll get through it. It says that the plea agreement is this, that you're going to be pleading guilty to count 1, which is an aggravated criminal threat. That is a severity level 5 person felony. The state's going to dismiss count 2, that's the theft. The parties are going to recommend to me to give you a downward dispositional departure, which will grant you probation, as well as a downward durational departure to 60 months on the underlying sentence. You are going to agree that given the fact that the state is offering to recommend those departures, that if you were to violate your probation by a new felony or misdemeanor charge, that that you understand that you would be revoked and not reinstated if that were to occur. In addition to that, in the old traffic case from 2018, you would stipulate to violation of that probation, that probation would be reinstated, that as part of your probation in that case, that you would need to complete an intensive outpatient treatment program, that you cannot consume illegal drugs or drink alcohol during your probation, that you must report, and you cannot drive unless you're validly licensed and insured and with an ignition interlock installed. Also, that all the jail credit for the time that you've spent in jail will accrue to the new case and not to the 2018 case. That's how I read the plea petition. Mr. Freeman, is that your understanding of the entire plea agreement?
So what you said is 60 months. That's like if I violated my probation, I do 60 months.
That is correct.
Okay, yes, I understand.
Okay. All right. Has anybody promised you anything other than what I just read to you to get you to plead guilty today?
No, sir.
Anybody place any force or threats against you to make you plead guilty?
No, sir.
All right. Now, I see there's a lot of talk about what's going to be recommended to the court for your sentence. But you understand that I'm not bound by any such agreement and that I can give you any sentence that the law allows me to. Do you understand that?
Yes, sir.
All right. Now, I kind of went up to the maximums here. What I have to do today, Mr. Freeman, is just assume that you have the worst possible criminal history, only for purposes of advising you what the maximum sentence possible under these cases, or this case is. Do you understand that?
Yes, sir.
Okay. So I see that the crime that you are pleading guilty to is a severity level 5. if you had the very worst possible criminal history, you could be sentenced to up to 136 months in prison on that. Do you understand that?
Yes, sir.
And that would also carry a fine of $100,000 and post-release of 12 months. Do you understand that?
Yes, sir.
I'm sorry, the post-release would actually be 24 months. And I think I'm right on the fine, $100,000. Is that right, Mr. Brinkworth?
The fine, Judge, I believe is on the, I'm sorry,
I don't have my.
on the 5 is a $300,000 fine, Judge.
300. Okay. So I'm not saying you're going to get that, Mr. Freeman. I just have to tell you the maximums are 136 months in prison, a fine of $300,000, and post-release of 24 months. Do you understand that those are the maximums?
Yes, sir.
Okay. All right. Mr. Freeman, do you have any questions about anything that you and I have gone over, anything in this plea petition, or anything touching on this plea that you need answered before we go forward?
No, sir.
All right. And knowing all this, is it still your intent to plead guilty to that severity level 5?
Yes, sir.
All right. Mr. Rivera, do you know any reason why your client should not plead guilty today?
No, Your Honor.
All right. Given that, Mr. Freeman, I'm going to ask you as to count 1, the aggravated criminal threat, which is a severity level 5 person felony. How do you plead, guilty or not guilty?
Guilty.
All right. Now I'm going to ask Mr. Brinkworth to tell me what he thinks the facts would be if this case went to trial. I want you to listen closely because when he's done, I'm going to ask you if that's what happened. Okay.
Judge, if I may, there was a preliminary hearing on this case. I don't know if the court still needs a factual basis.
We do have to, in order to take a plea, there has to be a factual basis on here. Okay. Mr. Brinkworth.
Judge, if this matter were to proceed to trial, the state would produce evidence showing that on or about October 12th, 2019, KCK PD Detective Eckel was notified by police dispatch to contact the Wyandotte County Sheriff's Office regarding a bomb threat at the jail. Detective Eckel called Sergeant Taylor and spoke with him, and Sergeant Taylor informed him that someone had just called in a bomb threat to the jail here at 710 North 7th Street in Kansas City and Wyandotte County. The number that the call showed to come from was 816-655-1464. Sergeant Taylor requested the department's assistance in the case and asked if they could trace the phone number. That number was traced through the TLO database and showed to belong to Brianna M. Stewart with an address of 5531 Everett Avenue in KCK. Detective Eckel mistakenly called the 816-655-1464 number instead of Sergeant Stewart. And the line rang and a male subject answered the line. Detective Eckel then called Sergeant Taylor, said the person who called from that number said there was a bomb in the building. Sergeant Taylor went on to say the subject sounded like a prepubescent male voice or an older female, like they were trying to mask their voice. He said this person called one time about 20 minutes prior and advised that they had locked down the facility and were searching the facility for possible bombs, including searching next door at Memorial Hall, since that was where a funeral was taking place for a Wyandotte County deputy. Sergeant Taylor then told Detective Eckel that they'd be searching for anything that could be a bomb, but if nothing was found, they weren't going to call out the bomb squad for a further search. Detective Eckel sent units out to 5531 Everett Avenue in KCK, try and make contact with Brianna Stewart or locate the phone associated with the number. No contact was able to be made at the location, so they responded to an additional possible address for Ms. Stewart on North 39th Street. At that location, officers made contact with Ms. Stewart, who told them at around 7 a.m. that morning, Reobert Freeman, the defendant, came over to her home and took her black cell phone, which has that number of 816-655-1464, telling her that it was his phone and that he pays for it. Officers then went to 6240 Yecker Avenue on a disturbance call where Patricia Freeman, the mother of Reobert Freeman, was arguing with her son and said she wanted him removed. They made contact with the defendant, took him into custody. During the course of the search incident to arrest of his person, they found the cell phone that Ms. Stewart had described with that phone number located in his left front jean pocket. Officers had then responded to the jail, spoke with Sergeant Taylor, and he advised that there was no background noise heard during the phone call, and they tried to keep the mail caller on the phone for as long as possible by asking where the bomb was, but the mail caller just kept repeating, "Bomb in the building." The caller was asked his name and he replied, "These nuts." Deputy Taylor advised that the phone call lasted 36 seconds. The sweep was done at the jail and Memorial Hall, but nothing was located. At the time of the threat, there were 424 inmates and 19 deputies in the jail.
All right, Mr.
All those
Freeman, you
events
heard what the
happened.
I'm sorry. You heard what the prosecutor had to say. Is that what happened in this case?
Yes, sir.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. He knows the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged that factual basis. I will find that he is in fact guilty of count 1. Pursuant to the plea agreement, count 2 is hereby dismissed. I'm going to order a pre-sentence investigation, continue sentencing until that date. We'll also continue the Revo case to the same date. Folks, my assistant has given me some possible dates. Let's start with April 5th at 9 a.m. Mr. Rivera, would you be available then?
Looks like I'm available that whole week.
All right, Mr. Brinkworth?
Yes, Judge.
All right. So sentencing will be set April 5th at 9 a.m. By Zoom. I will send out the invite. And Mr. Rivera, you're going to send that PSI request over to.
Yes, sir. Judge,
what I'll do.
I know I said I'm available. With my wife works overnights and she gets back. It just might be kind of a little close that morning. Could we push it back maybe half an hour?
You want to do 9:30 instead?
That'd be safer.
Okay, 9:30 it is. Mr. Brinkworth, I assume that's still good?
Yes, Judge.
Okay, that's when it will be. Anything else for our record today?
So you said April the 5th at 9 o'clock?
April 5th at 9:30. I'm going to send your lawyer that invite. We're going to do it just like this, and he will forward it on to you, okay? You keep in touch with Mr. Rivera. Here's what's going to happen. He's going to fill out this pre-sentence investigation request, and he's going to send it over to probation. They're going to contact you probably in the next week, but certainly within 2 weeks to set up an interview time to do your pre-sentence investigation. One of the reasons it's really important you keep in touch with Mr. Rivera is if for some reason wires get crossed and they're not in touch with you, you need to let Mr. Rivera know that so he can help make that happen and we can get our sentencing done, okay?
Okay.
All right. Vinny, do you need some time with your client to fill that out?
Well, Judge, I was going to call him, but if you want to leave us online together, that's fine.
All right.